the video of this later. Just as a reminder, all of these are recorded, and we do hold time for public comment at the end of each meeting. Just a couple of meeting norms that I'll remind at the start of every meeting. If you're a member of the task force and you're in a place, or the subcommittee, and you're in a place where it's safe and comfortable to do so, we would of course love to have you on camera. I also know days get long, and if you need to be off camera at some points, we certainly understand that. Members of the public, if you do join, we'll have time for public comment at the end. And just as our norm, as we do on every call, we do ask that when anybody's speaking, you introduce yourself. And we avoid using the chat. In fact, I think we may even have it disabled, hopefully. But we ask not to use the chat because it can be distracting, particularly for folks using a screen reader. But beyond that, it also just distracts from our conversations. With that, we've got a couple of guests here listening in. Representative Ortiz, who said hello just a minute ago and is here in case we have questions. Always appreciate you joining us, sir. And I see Josh from the Lieutenant Governor's office. Thanks for being here, Josh. With that, I'm going to dive us right in and kind of reground us and recenter us and update, since we had a little bit of a flurry of activity at the end of the year trying to see what we could pull together. And I want to explain to everybody where we are. Number one, I truly appreciate, and I know everybody does, the extra work that Ian and Andrew and others were doing to try to get us to some definitions that we might be able to come to consensus on. To remind everybody, or for anybody who missed some of the conversations, we were looking at the definitions of disability and persons with a disability, really with the aim of taking primarily the language that's in the ADA and bringing it directly into Colorado statute. Unfortunately, at our meeting where we were hoping to get through those and to update and to make those recommendations, we fell short of having a quorum. And I will fully own that we were trying to rush. I'm just letting Ian in, who's joining us right now. We were trying to rush to get through those definitions right at the end of the year, and I know over the holidays we didn't quite get there. It did allow us, though, to regroup a little bit. And as Ian is joining the audio, I'm going to pause for just 1 second here. It may be taking him a second. But one of the things that came up for those not on that call, or those who have forgotten over the holidays, we also realized that there may be some additional definitions. We started talking about the need for us to have additional conversations over time about things like reasonable accommodations. And Ian and others flagged the potential need to really get thoughtful about the definition of essential functions. And in fact, Ian has drafted something along those lines that pulls from some different case law, pulls from some rulings of the 8th, the 9th, and the 10th circuits. So we'll be circulating those. We didn't want to try to rush those and send them out and say, hey, here's these definitions, let's discuss them in 6 hours. We think they're important enough that we need to spend time. So where that left us was that the report ended up being the overview that you all saw in our last December meetings, which was laying out the process that this subcommittee has gone through, the topics you all have identified, and it was copied and pasted directly from what you all named, as well as the discussion of where we are on the definitions and the intent to continue working on those definitions. I apologize to you that I didn't get you a copy of the report. We were learning along the way about some new policies that exist, that anytime there is a task force or a working group offering recommendations that may address policy, we're required to submit that to the governor's office for a window of up to 30 days for them to review and comment and get back. So we've gone through all of that. I will be sending that out to all of you as we finish this call. There are absolutely no surprises. It's exactly what you all named, exactly what we put on screen. It just notes that we fell short of the quorum and decided that we have continuing to work to do on those definitions. And Ian, I was just mentioning to everybody that the much appreciated work you did adding for us the discussion of essential definitions. What I'd like to suggest to this group, though, is that rather than at this point trying to rush through definitions, we have an additional conversation about the ones to date: disability, persons with disability, essential functions. We can see what else to make sure we're comfortable with the language as of today. But my proposal to this group that I want to open up right now to discussion is, rather than voting on those right now, We can take a tentative discussion point on them and a bit of a straw poll at our next conversation. But we have a lot of topics to cover, from things like emotional distress to caps and other things. And my suspicion is that as we do that, we may come up with additional thinking on definitions. It may be additional definitions that you all name, or it may be nuance around those. So what I'd like to suggest is that rather than using any time today to try to push through a vote on those definitions, we circulate the additional definition that Ian's provided. We have a dedicated conversation on the definitions to date, and we put those in a holding tank that we continue to build on as we go forward with the work on our other topics, which I'm going to cover in just a minute, just to reground us in what we're statutorily required to do. But let me pause there and just open it to the floor for either questions or reactions to that approach of how we handle the definitions.
Since no one is talking, I'll start, Barrick. This is Ian Kelmanowitz. Happy New Year, everybody. Nice to see you all again. Um, since some of these definitions are hard, and in particular, since I spent some time after the meeting that we had where we wound up without the quorum, adding to the definitions that I had proposed. It makes it, I think, a little more difficult. So I am in favor of your proposal, Barrick, that we actually spend some dedicated time on this. I don't know if we should just start with the definitions of disability, qualified individual, essential functions, or we should add in something else. Do we want to tackle reasonable accommodation? Do we're a little bit limited in scope right now because as we kind of made it to the end of last year, I think we were kind of in a sprint to see if we could get something done for a report. But since we don't have that deadline looming over us, is it worth including some additional definitions? I will say that in working on this, I spent a lot of time, in both CADA and the ADA, and the two are markedly different in a lot of different ways. And so, I don't want us to do a whole bunch of work. Like one of the things I noticed in terms of qualified individual with disability is it's defined in CADA in the definition section, but then it's not used in the employment section. So, there were some of those sorts of issues that came up as well, but that got me thinking about, do we want to tackle some additional definitions, or should we get a couple done and then use that momentum to then get a couple more done? I will throw that all out to everybody, but I do think we ought to spend some time on these because they're not easy.
Yeah, I appreciate that, and I want to hear from the whole group. I think there may be this hybrid option, Ian, and that may be where you were going, that we go ahead and continue the work while those initial definitions that we had been working on are still in people's minds, and we can get through those and then put them in a file and say, we're going to continue to build on this. And it may be that each time we add some more. I just want to make sure we also leave the space that if we're talking on a new topic, we may say, hey, here's a new definition that we need to dig into a bit. What are other folks' thoughts on this general approach?
Yeah, so this is Andrew. I'm perfectly happy to continue discussing definitions. I just want to make sure we don't get too bogged down in talking about some of the definitions and not actually get to the larger scope of tackling some of these bigger problems. So just putting that out there, that would be my only hesitation or concern, I suppose, with going a little slower.
100%. And Andrew, to be very clear, once we finish this little segment of this afternoon's call, I'm going to talk us through the scope and our charges and offer a proposal, because you're absolutely right. We've got not only the legislatively directed topics we need to address, we've got more that this group has surfaced. And I want to offer to this group my proposal of how we're going to tackle a couple of those every month and I agree with you. I don't think we should get bogged down on definitions. My proposal would be we have a one-off call over the next 4 to 5 weeks just to go over the definitions to date. We set those into a holding tank and we continue to revisit as necessary, but in parallel while we're doing the other work. Does anybody have let me ask it this way, because I know we're getting into some wonky area here and a lot of it's just process. Does anybody have concerns about that approach? Okay, hearing and seeing none, then what I'm going to do, and we'll leave it on the table. I think everybody knows that although I can tend to be a little type A and will drive this meeting forward, if at any time you have an additional thought, just throw your hand up or lean into the conversation and say, hey, Bear, we need to pause and revisit something. But what I want to do is circle us back, Andrew, to your point of the work that we have to do and the work you all have identified that we should do. I'm going to read through the purpose and the deliverables that come from what we are required by legislation. The purpose of the committee is to study the current Colorado revised statutes concerning the civil rights of persons with disabilities and make recommendations for a thorough revision and rewrite to improve clarity, ensure the civil rights of Coloradans are protected, and ensure the protections are enforceable. With regard to the deliverables, our report at the end of this year must include, at a minimum, recommendations for clarity and improvement of the Colorado revised statutes concerning the civil rights of persons with disabilities, a discussion of damages for emotional distress for persons subject to discrimination, consideration for public entities and private businesses, including sizes of entities and general clarity on requirements to comply with Colorado revised statutes regarding the civil rights of persons with disabilities. In addition to those and building on those, you all identified the emotional distress, the caps and modernizing of dollars from 91, the timelines for filing claims, the standards for exhaustion, accountability measures, the public accommodation laws and incorporation of the 2010 DOJ standards, and burdens of enforcement and the role of the approving entities. I lay those out because now I want to talk about our timeline for our work. We are legislatively required to make our report to the task force by December 1st. We're working up against that. I also want to be realistic and pragmatic about other factors that exist. In particular, that the governor's budget is usually introduced in the first week of November. And then I backwards map from that, and we have our friends in the legislature who are generally pulling bill titles around that time or a little earlier. That's not at all to suggest we need to move up the deadline for our full report, but I would suggest that we may want to think about having the meat and the substance or the concepts so that we can be sharing those in case they do call for 2025 legislative session work. That being the case, what I would suggest to this group is we probably want to be spending September and October finalizing our recommendation. And to me, what that looks like is starting today and monthly through June, what I would like to suggest is that every meeting is 2 of the topics that we want to address. And what I would suggest is that at each of those 2 meetings, we in advance would probably do some reading or some sharing of information. At the meeting, it would be, for example, the introduction to a topic. Let's say that today we start talking about emotional distress. We would start the day by putting on the table all of the aspects that are on your minds, the different issues that we need to consider within it, where people are starting, and it's really the learning part or the initial grounding for that topic. We would then share more information that you request or identify. If you tell us, we need this type of research, we need this type of background, we would share that between this and the next meeting. And at the next meeting, we would then start the conversation about solutions and recommendations. To be very clear, not with the intent of finalizing them, but with one meeting to learn, time in between to do some thinking, some reading, and some sharing of resources that you identify you need. In the second meeting a month later, digging really into the details of it and where we think we want to go with that and starting to frame the concepts of our recommendations. At that February meeting, then, we would start the introductory conversation of the next topic. And so maybe that is something aligned like caps and modernizing dollars. So the goal would be we have 2 meetings for every topic at minimum, with one being an introduction, the second being a discussion of solutions. And if we couple 2 of these and leave room to need potentially a third discussion on some of these, my belief is that by June, we will have gotten through the topics at the high level and the base framework of ideas, and can also include along the way, if we need additional third discussions on any of those, spend June and July as a group really digging into the specifics of recommendations, and at August start reacting to some drafts, so that going into September and October, we're drafting recommendations. And I realize that for some, the project planning wonk in me, it may seem a little over the top. I'm trying to make sure we have a plan that gets us effectively through all the issues you've raised, gives us time to thoughtfully address all of them, and obviously puts at the forefront the issues we're legislatively required to address. Going back to the piece about definitions, what I would suggest is that along this path, we set aside 10 to 15 minutes of each of these, say, are there any implications for definitions that we now need to be considering based on what I will refer to as our old business and our new business at each meeting. I've thrown a lot out on the table, and we haven't even talked about one of the topics, which I intend to do next. But I'd love to get your thoughts, because frankly, we are facilitators and we're here to support you. You are much more the subject matter experts and the stakeholders with lived experience and professional experience. Does my proposal seem right in basic concept? How do you guys feel about approaching it this way, of going along a continuum of issues and we build upon them each month?
This is Alana. I really like the splitting it up into the intro and kind of the follow-up dig-in sessions. I think that's a really nice way to make sure that, because we'll all come in with different levels of knowledge initially for each of these topics, so that will give us all time to really digest everything and hopefully be able to bring as much as possible to the conversation in that second meeting or follow-ups as needed. So yeah, I think that's a good way to approach it.
Thanks, Alana. This is one where I probably will call on people, because I really want to make sure we're being responsive to where you all are. And I understand everybody's coming in differently. My goal is to make sure that I don't ever bring a topic and you feel rushed or forced to try to vote or recommend something before you've had the adequate time. So let me go to Tom Wheaton and then Lauren for thoughts, and I'm going to continue around the room.
Yeah, I agree with Alana. I think this is a very wise approach, and knowing that we'll have information prior for us to do our homework so that we can come somewhat informed and then eventually hopefully come to consensus during those month meetings. I think that's a wise approach. We'll look at the $35,000 level or 35,000 foot level until June, and then we'll really polish everything up July and August and et cetera. So pretty wise approach.
Great. And Lauren, I'll go to you in just one second. I see Cindy with her hand up. I also want to name that incorporated into this new business, old business learning will be stakeholder consideration. And at every topic, we're going to be asking you, who else do we need to be hearing from? But Cindy, I see with you with your hand up.
I thought you were going to call on Lauren next. I just want to make sure I'm not skipping past someone.
No, I think you on camera. Jump in. I'll go to Lauren right after you.
Okay, fine. So I just have a couple of questions, and one you just touched on, which is stakeholder engagement, because in this process, I think that we routinely want to build in the ability for those of us to reach out to various stakeholders, and I'm not sure if it would make sense to reach out between introduction to the topic and getting into the meat of it. I almost think that once we get into the meat of it, we will come back to a third point, which is finalizing a topic after we do some stakeholder engagement. So I almost think, in my mind, it's almost a three-step process, but maybe I'm making it more complicated.
Cindy, I don't think you are at all. And later today, I'm going to have Carrie talk about some stakeholder engagement tools and resources we're going to use. One of the things that I will be incorporating into every issue or topic discussion are questions for you about when you want to engage stakeholders. We will have an online platform and some other tools. To me, the options, Cindy, are really at least 3 points. One, we could engage people at the very earliest and say, we're going to be talking about this issue. What do you want us to include in our discussion? Second, we could, as we get very high level, 30,000 foot thinking, we could share out, this is where our current thinking is. What are your responses or additional guidance? And certainly as we get these more fleshed out, we'll have the opportunity.
Okay. All right. That's helpful. And it'd be nice to take a look at that. And the second part of my question is, does your timelines take into account the need to send our drafts to the governor's office for their up to 30-day review?
So this is a place, and I would love all of your input, and I'm going to have to talk to the task force itself. We are required to deliver our report to the task force on December 1st. That's not one that's being released. My only concern about that December 1st task force is that might limit 2025 legislative session activity on it. If you all recommended something, for example, that said the Civil Rights Division needs 32 more full-time employees to review things, I think Aubrey would probably support that. I think we would have some questions for people on the fiscal impact. That's not me weighing in on that suggestion. It's just giving an example of, if we have recommendations that carry fiscal impact, we'll have to consider how soon we can at least give a heads up to people. But my timeline prepares us to deliver, I think, ahead of the December deadline. My goal would be that we are drafting recommendations over the summer. We're drafting the report in August and September to finalize it for late September, early October, so we're ahead of that curve. Long-winded answer, but I wanted to share my thinking on it and some of the variables that we have.
Thank you.
Okay, with that, I'm going to go to Lauren and then to Andrew.
Yeah. Hi, everyone. Lauren speaking. And Cindy's comments actually reflected what mine were too, particularly regarding stakeholder engagement. As I've shared with this group in the past, I come to this role with a little trepidation because I've been asked to represent the business community, and I want to make sure I'm taking that, whatever we discuss here, back to the business community or inviting them to the forum. If I've heard that you want to hear from chambers of commerce. So giving the business community something to react to. And again, falling on the fact that I'm not a lawyer or a lobbyist or policy expert, just not knowing some of the nuances personally. I want to make sure that I'm doing my best work and getting everything that we talk about properly vetted with stakeholders so that I can share the concerns of the business community or the ideas of the business community. So I do appreciate the thoughtfulness of our path forward as far as the process and the cadence of meetings and that time to prepare. I have my observation of the last few months has been that we start down a topic and I feel like we veer into a number of different places, which is to be expected. No pointing blame. It's been an interesting process, but I think that will help me better represent the constituents you've asked me to represent.
Great, I appreciate that. And that is our goal. We want all of you to be able to be looking at next month and 2 months out and saying, I'm going to need to be ready to discuss this. Who do I need to talk to in my world, or what do I need to ask Carrie and Barrick to provide me to be ready for it? And in all of this, our goal really is threefold with this stakeholder engagement and telegraphing what we're going to be talking about. Number one, we want this to be the most broadly and diversely informed set of recommendations. So we want as many voices and perspectives as possible. Number two, we also want to make sure that we're putting forward recommendations that can get advanced. So we want to stress test them a little bit. So you may hear from somebody, hey, I have a concern about this, or this would make it better, which gives this group the opportunity to make even stronger recommendations. And third, I don't want anybody at the end of this to say, next February when a bill is introduced, this is a surprise to me, I never had the opportunity to weigh in. Our goal is going to be to make sure that as many people as possible have that opportunity now. Let me go to Andrew and then Ian for your thoughts and comfort with how we're staggering this and the approach we're looking at taking.
Thank you, Barrick. This is Andrew. I think what you proposed is sensible. I think there may be a few times that we'll need to have an additional ad hoc meeting just because something is a pretty thick topic. Again, I just want to make sure that we're able to get through the entirety of what we need to. I mean, I was really hoping we would have been able to pick off some of that low-hanging fruit for our earlier report. Obviously that didn't happen. But I think as long as we keep the fire under ourselves and continue working, we can come up with some good recommendations come that second report.
I appreciate that, and I share all of those same feelings of aspirations and some slightly missed aspirations. Let me go to Ian and then Tom Aker.
Thanks, Barrett. This is Ian. Yeah, I agree with this proposal. I think the idea of being sure that everybody has adequate time to learn these things. Some of these issues. I mean, these are issues I live and breathe every day, and I don't need that same degree of background or education or time to review these things. But I want everybody at the end of this to know what we were talking about. And at the end of this, maybe we'll mint a few new employee or civil rights lawyers that'll go out and help people with disabilities. But I also agree with Andrew, and it may require, because of the idea of spending some time on something and then revisiting it, in subsequent meetings, we may need some additional meetings beyond just our 1 month meeting or monthly meetings, because some of these topics are going to be dense.
You are heard and understood and agree. Tom, your thoughts, Aker.
Thank you, Barrett. Tom Aker. Sorry, it's a little late this morning today. Only thing I would add, I agree with everything, is maybe list at the bottom of the agenda what topics we're going to cover maybe the next 2 meetings. So if we need to do some extra prep, we can do that. So we've got a heads up on what's coming up.
I love that idea, Tom. And I think what we can probably do is put a tentative / draft 6-month arc of conversations on the website and distribute it to everybody. Keep that updated. And as you suggest, on every agenda, make clear what we are talking about that day and what we expect to in the next couple of meetings, and possibly even with some bullet questions for people to be thinking about. Does anybody else want to weigh in before we start talking about the sequencing of these topics? And if things go right, diving into the first one today. Lauren, please.
Yeah, hi, Lauren Schwartz speaking. I did have a question from before the new year about our process too, and I think I'd ask this of you, Barry, because we talked about the voting process or how we come to consensus or not. And I realize these are public meetings and it's being recorded and it's open to public consumption to see how we're following on something. If we get to an issue that we're not able to come to consensus, or don't even use the word consensus, let's say we're not in 100% agreement, so there's no question about it. It's not been defined what is a quorum, or are we going by a quorum, or how will that be recorded, or could we demonstrate if we aren't in 100% agreement? 3 out of 12 I disagree or agree. It's just a process question.
No, I appreciate you raising it, Lauren. This is Barrick, and Carrie and I were actually talking about that over the last 2 weeks, and maybe we do have time on the agenda now, so maybe we can have a brief conversation at least now. I will tell you, the task force itself has not given us specific directions. It's an issue I'm going to be speaking with them about. In the absence of any separately identified quorum or voting thresholds, I operate on the standard definitions of those and of majority. We have not been instructed supermajority. That said, we'll see if they want to give us any further instructions. I also want to open it up to all of you. And I will tell you that my goal as a facilitator, number one, I'm not naive enough or young enough to say we are all going to agree 100% unanimously on everything. My goal will be to find what is the greatest level of detail where we do have consensus, so we can first identify that. For example, we may be able to say that 8 out of 8 members support this, but when we went, and let me just throw out an example, that if we say emotional distress, maybe 8 of 8 members say it should be in this range. We may have 5 of 8 members that say it should be that as the minimum or higher. And I'm not trying to suggest that be your recommendations, just as an example of, I would hope we can identify where we do have full consensus. My intention would be that we are very transparent with the task force, that this is what the group agreed on. These were the issues where we couldn't, and more than just saying where we could not, report up to them that these were the concerns raised or the points made by both the majority and the minority on any of these issues. But let me open it up to all of you with your thoughts. But before I do, Rep. Ortiz as our vice chair.
Yep, I think that's extremely intelligent way to do it. My only other ask would be to make sure that where we don't have consensus, like, and you identify majority and the reasoning why, minority the reason why, that we also include the vote count breakdown. I think that'll be important for the major task force to see, because obviously we'd want to push forward where we can have either all consensus or a greater majority forward first. Like that, it's important for us to see where the breakdown of the votes were.
Thank you, sir. Appreciate that clarity. Thoughts on this general approach, pending any additional guidance I get from the task force? It looks like we will move forward with this. I will bring back any additional guidance. Otherwise, that will be the approach we take. It is an abundance of transparency with an authentic commitment to seeing where we can work through to get to the greatest level of agreement, and respecting when we don't, being transparent about it. So that brings us to starting to dig into the issues. As I read our required deliverables, the ones that are identified, in addition to the general recommendations for clarity and improvements, the first items are a discussion of damages for emotional distress for persons subject to discrimination, considerations for public entities and private businesses, including size of entities, and general clarity on the requirements to comply. That is not at all limiting, because we also identified things like caps, timelines, standards for exhaustion, and accountability measures. My suggestion to you, and this is building on what we heard from all of you in our December meetings, was that we need to establish some sequencing. We've got some tough issues. I'm all for ripping the Band-Aid off and going right after them, and getting into it. So my suggestion or proposal that I am very open to pushback on, but I'd like to hear advocacy on sequencing, would be we go straight to emotional distress. And as we work through it, we give it the time that it's going to take, and then we talk about caps and modernizing dollars. But I welcome, I'm going to open the floor if people have other suggestions, either for the first one or two, or general thoughts on the sequencing, if you have a strong feeling that something needs to be dealt with before we can get to the others, or it may inform the others. Mr. Montoya, please.
Thank you, Barrick. This is Andrew Montoya. So I completely agree with putting emotional distress damages right up front and getting to work on that. Just to kind of give everyone a little bit of background and hopefully not repeat too much of what I may have said in prior meetings. The Colorado Anti-Discrimination Act had been read to allow for emotional distress damages for decades. There were some changes to the Colorado Anti-Discrimination Act when we had made some updates to include some expanded protections for people with service animals. Anyway, long story short, the Colorado Anti-Discrimination Act at this point has been read to not allow for emotional distress damages. But we always had what we would consider essentially a fail-safe in Section 504, which is a federal law. We could use that as well, and that allowed for emotional distress damages if you were able to prove intentional discrimination. Just a few terms ago, at this point, it's probably 2 or 3 terms ago, the Supreme Court issued a decision that went the other way on that, overturning decades of precedent in Colorado and the entire 10th Circuit, as a matter of fact, and a lot of other circuits throughout the country, which ripped away the ability for us as attorneys representing people with disabilities to get emotional distress damages for our clients. And the final point I'll make with that is that when you're talking about disability discrimination, of course, the first thing you want to do is get an injunction to fix the problem, make sure it doesn't happen again. But disability discrimination is one of those things that's not really about a huge pecuniary gain. You're not losing a whole lot of money. You're not losing necessarily a business opportunity. It's that you're not able to get into, say, your son's graduation from high school because there's no ramp for you to get in through the door. You're not able to take part in your spouse giving birth because there's no sign language interpreter for you to be able to communicate with your spouse or any of the medical staff. So you're kind of shoved off into the corner. You're missing out on opportunities that you're never going to really be able to get back. And the only way that the justice system allows for compensation for that is through emotional distress damages. So when you're talking disability discrimination, it's all about emotional distress damages. So I think that's one of the most critical issues we can tackle straight up.
Thank you, Andrew. And you kind of already took me to the next phase, which is where I was going to ask people to start sharing initial thoughts. I'm going to come back to you for some thoughts. Before I do, though, I want to go back around the room on the question of sequencing. Because again, as I did with process, I want to make sure that the sequence feels right to everybody. I think this in particular may be one that we're not going to get done in two halves of two meetings, and will require some additional. But does anybody have thoughts on either my suggestion that we go there first on emotional distress, or on other topics that you want to see at least early in the sequencing of conversation?
Merrick, this is Tom Wheaton. I agree with Andrew that this really is the elephant in the room. And I would really want to be able to have as long a journey as possible on that, so we can get everybody's, honest take. Everyone needs to be heard. I get the sense that opinions are all over the map on that one. And so I feel like once we can get that discussed and processed, the other areas that we have are important, but I get a sense that we'll have more likelihood for more of a majority to move forward on the other one. So I wholeheartedly agree that for sequencing, this really needs to be topic number one.
Thanks, Tom. And I think you'll find at my heart, I'm just a stubborn old Marine who looks for the biggest hill to go try to climb as quickly as possible. So I say we take on as you said, the elephant in the room. Ian, your thoughts?
Yeah, thanks, Barrick. I agree with the sequencing, and I agree with everything Andrew and Tom had to say, and what you had to say. Except I don't agree that the emotional distress damage is going to be the elephant in the room. I think the caps are going to be the elephant in the room. Okay. And but it makes sense for sequencing purpose to address emotional distress first, because number one, that was our mandate from the task force and from legislation. But number two, I think it will help, because a lot of the things that we will be discussing when we discuss emotional distress are really foundational to the issue of these caps. And, I almost think about it in terms of it greases the wheels a little bit for both educating everybody about the damages that are available and also getting into the rationale behind the caps and whether you agree or disagree with the caps, what should be done with them, particularly in light of the fact that, for the public accommodation types of disability discrimination, there are no emotional distress damages available, or if it's in the employment context, they're very limited because of these caps. So, but I think dealing with the emotional distress damages question first will really prime us for what I do think is the elephant in the room, which is the caps.
Fair enough, and appreciate that perspective and push on that. I'm not looking to cut the sequencing conversation short. I am reading the room a little bit and seeing some consensus on this. And my real interest is in getting into the topics themselves. Before I do that, would anybody like to weigh in on the sequencing? I think where we are right now is we've got a baby elephant and a big elephant, the 1-2 of the emotional distress and then the caps as our first two topics that may continue to get informed by our additional conversations. Cindy, your thoughts?
Yeah, I just want to add something in, and I'm not sure if it has to do with sequencing or just keeping in perspective that when we talk about damages and emotional distress, we're really talking about essentially the long range way that we are addressing or enforcing discrimination laws, because we know right now they don't work. And so I'm thinking that along with considering the first step of looking at emotional distress, looking at damages, we also need to continuously be looking at our measures of enforcement. What else can we do to strengthen the law? Because the fact is, things don't work. And while I appreciate that, I appreciate the fact that there are considerations, there are effects, if you will, to a person's life if they can't participate in somebody's graduation or they can't, observe a spouse's birth, of their child. There are also consequences for people who lose a job because they not once, twice, but three times don't get a ride with Uber because they have a service animal. And so I guess what I'm trying to say is I think we need to look at this as one of several things that we need to make sure that we do whatever we can to strengthen the law to make sure that the law matters.
Really appreciate that, Cindy. And I'm seeing a lot of nodding heads. I think it's an important reminder that as we go through every conversation, we keep on a front burner what are the other implications of the discussion and the topics we're exploring. If it's okay with everybody, then I'm going to go ahead and move us into what will be, normally we'll do some prep, but I'd like to move us into the first topic discussion for our work and go into some conversations around emotional distress, unless I see any objection or anybody wanting to weigh in on sequencing. So seeing none, my approach to this is going to be the following. I'm going to ask first for people to share where they are coming into the conversation on this issue of emotional distress. And this is one of those places where I go back to the norms we shared when we first came together a few months ago. I want everybody to be very comfortable sharing and owning your perspective. I'm going to ask everybody to listen and focus on listening rather than your response, and to respect and assume the best intentions from everybody else. So what I'd like to do is first go through a round of listening to everybody where you come in on this issue. And that may be, I have a strong feeling and it's very detailed, or I have a general feeling, or I have a lot to learn. But I'd also like you to share kind of your initial thoughts on the issue. And that can be framed however you would like. There's no right or wrong answers. My second round of questions to the group is going to be, what do you need to learn and who do you need to hear from for us to continue this conversation? And that can range from, Barrick, I need to hear from all of these different stakeholders, or I need to learn about the historic changes that took place that Andrew was sharing with us, or I need to understand the data behind claims, or I need to understand what other states are. But the first question is going to be, where are you coming into this conversation? The next one is going to be, what do you need to learn or hear from? And then the third part is going to be, what are the discussions you want this group to have to be able to start developing those recommendations? So again, this will be one of the few places where I do call on people, because it's important that I understand and everybody hears from one another about where you're coming into this. So I'm going to start, and people get the fortune or misfortune of me going in order of my screen, which means Tom Wheaton and then Lauren. I'm going to ask you, where do you come into the conversation, and what is kind of your baseline understanding or thinking about the topic of emotional damages in our laws?
Thanks, Barrick. I had some initial thoughts when we started in October, November, and this group has opened up my mind to understand that this is not a black or white situation. This is not cut and dry. There are various things that we have to consider when we try to propose a rewrite. And particularly with emotional damages, Andrew talked about intentional discrimination, but we've had conversations that there is perhaps a more innocent or discrimination that goes on where business owners and or approving authorities do not know, what the discrimination is and lack of access, etc. So I feel like we're going to have to pinpoint that a little bit. And then, but as I shared with everybody before, one of our first meetings, my perspective is that emotional distress is very real. It's very profound, and the words that always come to my mind and to a lot of my peers for the last 35 years are, it could lead to depression, it can lead to isolation, and unfortunately, it could lead to suicide when people feel devalued because business owners and or approving authorities are either ignorant to the standard or willfully discriminatory, and sometimes perhaps just don't want to deal with it, and they can get kind of rude to the individual. So those are kind of my pointed feelings, but the solution for all of that is kind of a puzzle we have to put together. And as I said, I met with a friend of mine in Pennsylvania I haven't seen in 35 years, and he's a lawyer dealing with a lot of this stuff. And he said, with your group, my only advice to you is be as clear as possible, which I know will probably end up being clear as mud. But hopefully this year process will get us somewhere closer to where we want to go. Because I think Cindy's comments earlier are right, that what we have for a law right now doesn't work, and we need to find solutions.
Thanks, Tom. And I think we need to be comfortable with being the ones that throw that giant boulder into the lake and stir up all the mud on the bottom, because that's the only way we're going to find something new as that all clears and settles. We go to Lauren and then Tom Aker and then Cindy. Your initial thoughts, Lauren, on where you come in on the topic, and just your initial thoughts about the spectrum of issues here.
Well, I'm going to limit it just to emotional damages. Maybe not the full spectrum, if that's okay with everyone.
No, the full spectrum within that.
Okay. Yeah, thank you. I have no doubt that when any law is broken, there can be consequences that include emotional damages for people. And that's why we have laws there, so we can all get along. And the law is law. That's why we have them. So I don't want anyone to think that I don't acknowledge that, and that when laws are broken, particularly the laws that are put in place to ensure that we can all have access, there's no doubt in my mind that it causes emotional damages. I've heard you all tell some stories that would make people's heads spin, and I can tell you, having worked with an organization that supports people living with a disability, I've heard some stories that were made our stories that we've told sound like bedtime stories. They were so egregious. No, so I want everybody to know I absolutely acknowledge that. And with that said, looking at emotional damages, I don't know how you measure that. When I hear emotional damages, I think of damages that are awarded by a jury, and those can really vary depending on the emotional state of that jury, I would suppose. So that's where it's going to be very difficult, and I can, without having taken that to the business community, I'm sure businesses would have great concerns about how do you measure emotional damages and put that into statute. It's a tough one, guys. It's going to be something business community is never going to be on board with, adding emotional damages to this. So now, with that said, what do I need to learn? I mean, I was really curious. Some of my colleagues on this committee are so learned, and I learned so much from you. I was really interested in hearing Andrew's recapping the history of where this fell into law and then came out of law, and just curious, what the opinion was of the Supreme Court when they took emotional damages off the table. If I understood that correctly, Andrew. So I guess I'd be curious to learn more about that, what the opinion said.
And Andrew, I will probably tap you to talk about that later in the conversation. I really, right now, instead of getting into actually learning, what I want to do is just focus on the learning that we're going to need. But really, on this question, it's about where are you coming into this conversation and what is your baseline view? And Lauren, I really just appreciate you naming upfront some of the things that we're going to need to talk through and work through, and the realities of some stakeholders' perspectives on this. Let me go to Tom Aker and then to Cindy, and where you come into this and your initial baseline of thoughts.
Thank you, Tom Aker here. I would say where I come in from this is I need to learn a lot. Even though I am handicapped, I need to learn more about the levels of emotional distress and the damages that might be associated with it, because I see it could be wide ranging, and I echo what Lauren had said is, how do you measure that? And then how do you, this may not be the right word, how do you compensate for that, for the different levels? And how do we put that in statute? Because it's going to be wide ranging in my mind. But having a lot to learn, I'm very open to learning what's been done and what's been done in the past, and where some of our more learned people are recommending we go.
Thank you, Tom. Let me go to Cindy, and then I'm going to go up to Ian.
Yes, this is Cindy. So I think in this arena, I have a lot to learn. My experience and individuals who are deaf, hard of hearing, deafblind, blind, low vision, very low incidence of success in the area of being able to prove not only emotional distress, but intent. Intent is probably the most difficult thing. And this is because of sensory, having this sensory limitation of hearing and vision. If you think about the fact that communication is 95% visual, and if you're a person who's blind or low vision, and you're in a workplace where people are actively, as a group, communicating with each other, something that's disrespectful, it's happening, but you can't prove it, and you don't see what's going on amongst folks. Same for folks who are hard of hearing and deaf, or those individuals, let you know that maybe what you heard, you misunderstood, utilizing, your disability in a sense against you. My experience is intent is much harder to prove for folks who have sensory limitations, period. So I guess I have a lot to learn, and I'd like to see, some cases where there has been success, particularly with intent. My feeling is I go more for consequence, as a consequence of X, Y, or Z not working for an individual, them not having access, or them being limited or barred from being able to participate equally. Whatever the consequence is, that should lead the damages and the emotional distress of that, and staying away from intent.
Got it. Thank you, Cindy. I'm going to go to Ian and then Alana. Ian, you're a lawyer that works in this space. Where do you come into this conversation? And on next round, I'll ask about what conversations and learning. But what is kind of your baseline and sense of what it is we're going to need to explore it, and where you come into the conversation?
Well, I come into the conversation strongly in favor of these emotional distress damages being available. And, I come to it both because of the space I work in, but also because this is how we as a society have decided that we compensate people for harm that they've suffered. And if we take this outside of the discussion of discrimination, and we look at it in the context of something like defamation, for example, if someone makes false statements about you that harm your reputation and your standing in the community, you are entitled to recover damages for the harm that you've suffered. And that includes the dignitary harm, the hurt feelings, for lack of better way to describe it. And we've decided as a society that we do that by taking money from the bad actor and giving it to the person who is harmed. And so, this is not like a new concept that we're proposing to throw out. We're not proposing a groundbreaking idea here. What we're doing is enshrining in the law what our justice system is built on. And this, that's one part of where I come from on this. The other is that these are real harms, right? These are real actual harms that people have suffered. When it is, I'm not just talking about something like a door frame might not be wide enough or a counter might not be low enough, but these are real harms that people suffer when they're specifically deprived of the ability to participate in society. I will add, I don't know if anybody saw this, but there's been news coverage of this. For example, a deaf lawyer in Denver was deprived of the right to be on a jury. Now, this guy is a trial lawyer who goes to court and regularly tries cases. But before he even showed up in court, the judge and the two lawyers on both sides of the case decided that he should be excused from jury service because of his deafness. And he should be entitled to participate in society. And if he's denied that right, he should be entitled to recover. He should be entitled to recover money for the harm he suffered. So that's because these are real harms. So there's our society functions this way. Everyone should be entitled to participate in society. And then there's the deterrent effect of having these damages event. And, I've said this, I think I've said this to this group and I've said it to countless other groups that I participate in. I want to be out of work. I don't want to do this. I want our society to be such that nobody is being discriminated against. There's plenty of other things that I can do, right? I'll write wills. I don't there should not be a need for civil rights lawyers. There should not be a need for discrimination lawyers. And one of the ways to put a stop to discrimination is to put the people who do discriminate on notice that if you do this, you're going to have to pay for the harm that you caused. And if that means then that you need to pay more attention to building codes, pay more attention to design standards, better train your staff, ensure that you have accommodations available, then you do that. And that's a cost of doing business. And it's significantly cheaper than paying lawyers, buying insurance, and paying judgments if you discriminate. And I don't like the idea that that's how we have chosen to police ourselves, but that's how we've chosen to police ourselves. And we have an ordered society because of it. And so, adding this to the statutes that exist already is not going to create such a drastic change that it will rock the very foundations of the state. Businesses aren't going to flee Colorado. I know, and I appreciate the business's concerns. I am a small business owner. I remind people of that on a regular basis. These laws create a burden on people, but that is the burden that we have to accept to live in this society. So.
Thank you, Ian. Really appreciate the perspective and the framing. I think you've also probably given me a new topic that I now need to take back to the government subcommittee when you raise things like jury service, and they're talking about participating in all government programs and services. I'm going to go to Alana and then Andrew. I know you weighed in, but I'll open the floor if you've got additional thoughts. Alana, on the basic question of coming into a discussion about emotional distress, what's your entry point to the discussion, and what, if any, are the topics that are on your mind here?
Yeah, I can't live up to the impassioned speech we just got from Ian. That was pretty impressive. Broadly, I can say, obviously, I think that the emotional damage is very, very important. It's real harm, and that's something that if that's not being addressed, then that needs to be addressed. And just the kind of big thing that keeps popping up for me while I'm thinking about this is everything I understand about legal anything, which not necessarily a lot because it's not my industry, But everything I understand is that there's barriers to entry to know that you have a case, that you can even have rights to push back about the fact against the fact that you're being discriminated against. And then there's barriers to, do you then have the resources of time or money to pursue that case? Can you get access to a lawyer? Can you spend the time required to go through all of this and make it to the end of the entire process, and then maybe even have to do whatever follow-up required to then get a settlement actually out of the other person? So just knowing that there's already all of those hurdles kind of built into the system, just because bureaucracy exists and we do not yet live in a perfect society. I am less worried about the business community. Not that I'm not worried about them, because never the goal to drive people out of business, anything like that. But the system in many ways is set up so that it's easier on that side than it is on the side of the people trying to prove that they have been discriminated against. So for anything where we're talking about how much we can then help those folks, that's where I would like to be putting the most of the focus and effort. That was poorly phrased, but that's what I've got.
That's great. Thank you, Alana. Andrew, I think we have a sense of where you come into the conversation, but I'm going to give you the floor just the same.
Thank you, Barrick. Yeah, this is Andrew Montoya. Just to kind of touch on a couple of the points that others have raised. Alana was just talking about some of essentially the red tape that it takes to get to the end goal of essentially eliminating discrimination and making whole the person who was discriminated against. That's one of the reasons that I think emotional distress damages are so critical in this area. When we're talking about injunctive relief, which would be an order from the court to fix whatever the discrimination was, institute policies, go to training, whatever the case is, there are judicial standards that we've got to prove. We've got to prove, based on, again, Supreme Court precedent, that same individual is going to be subject to that same sort of discrimination again. If you're talking about someone who, for example, has gone into a store and was kicked out because they had a service animal, that person can say they may go back. But then we've got to prove all of that. And we've got to prove that they are going to be subject to that same discrimination again, which is a pretty high burden to establish that not only did they do it once, but they're going to do it in the future. It's very tough. Ian had talked about the case involving the deaf lawyer. I actually represent that individual. That was the trial I was supposed to be at. Unfortunately, the day before trial, the afternoon before trial, the court issued an order on the defendant's motion for summary judgment. One of the many things the court found is that we could not prove that juror was going to be subject to that, or that individual was going to be subject to that same discrimination in jury service in the future, because who knows when you're going to get a jury summons? No one ever knows that. And beyond that, who knows why you got kicked off of a jury? And beyond that, how many people actually want to serve on juries who would then sue to be on that jury? Well, the court decided we didn't meet the standard for obtaining injunctive relief, among a couple other things, and therefore we never even got our day in court in that case. So when we're talking about emotional distress damages, we've got to put it against the background that even though we may be able to prove that what happened and it was in fact discrimination, we still might not be able to get a court to order that discrimination cease. We might not be able to get that injunctive relief. Emotional distress damages, however, still provide some way for us to get some relief for that individual. We can get them at least some money in their pocket. It's never going to make them quite whole, but some money in their pocket to at least show that what's happened in this case is not okay and should not happen again. One thing I know for certain is, businesses certainly speak and listen with their purse strings. So even though we may not be able to get injunctive relief, or even if we can, or frankly, even if a defendant gets all the way to trial and says, oh, well, we've instituted these policies, therefore your case is now moot, we can still get some relief for our client. So that's why it's so critical. Touching on one other point, I also don't think that intent should be required. That's what was required under Section 504, based on some phrasing in the law and, as interpreted by the courts. But I don't think that we should make emotional distress damages require a showing of intentional discrimination. As Cindy mentioned, that is not a successful thing. I've litigated cases and indeed attempting to show intentional discrimination, very similar to the example I gave. It was a doctor's office that kicked a woman out of his office because she had a service animal. She was going to him for diabetes care. Her service dog was for her diabetes. But he looked at one sheet of paper. It didn't have a number that showed that she was in the diabetic range because lo and behold, she was taking insulin, and he kicked her out of his office. In that case, we got that woman emotional distress damages under the Colorado Anti-Discrimination Act as it existed at the time. But we weren't able to prove to that jury that it rose to the level of intentional discrimination. Intentional discrimination is a very high bar. And as we've talked about, a lot of the times when you're talking about disability discrimination, it's not animus against people with disabilities. You're not kicking someone out because you don't like people in wheelchairs or you don't like people who are blind. It's, benign neglect. It's not even thinking about, oh, is this doorway going to be wide enough for someone? Or, oh, are we going to have a sign language interpreter for, full access for people? There's not necessarily that intent, but the discrimination is the same. So I 100% agree that intent should not be required for obtaining emotional distress damages. And then finally, just kind of perhaps give Cindy a little bit of comfort. The Colorado Anti-Discrimination Act at this point does allow for actual monetary damages. So in the case of people losing jobs because Uber is continuing to not pick them up because of their service animals, there would be a way to put that together as, actual monetary damages and show the pecuniary loss. But so many other cases aren't that way, where, there's not going to be that huge monetary amount that you can actually prove, dollar for dollar, I lost out on this job, for example. So that's why I think the focus should be on emotional distress damages more so than the other, the other flavors of damages, so to speak. Thank you.
Thank you, Andrew. And I want to thank everybody because I think, and I'm going to just name right now, this is clearly not a topic we're going to get through in half of 2 of our calls. So I want to assure everybody I'm not going to rush this conversation. I'm looking at the clock, and for better or worse, I don't see members of the public on, which means I can continue our work through that public comment section. It's 4:05. What I want to do is spend the next 15 minutes talking through who we need to hear from and what we need to learn. I do need to hold some time at the end to make sure that Carrie can talk through some of the stakeholder tools that we're going to use. But my next question, as we look ahead to continuing a conversation and next month starting to really get into what Colorado statutes should look like with respect to emotional distress, I'm going to go around the room and I'm going to start with Tom Aker, and then I'm going to go to Cindy, and want to hear from folks 2 things. And I'm going to ask you to try to be in about 2 minutes, just because I want to get to everybody. But number one, most importantly, what do you need to be able to come back in February and have a conversation to start workshopping what the framework of a better system should look like? Is it data? Is it lived experience? Is it perspectives? Is it exemplar laws? Is it the Kelleher ruling? What is it that will be helpful to having that conversation? And if you have it in mind, are there stakeholders, individuals or groups or constituencies you think we should hear from in this process on the topic of emotional distress? I'm going to go first to Tom Aker and then to Cindy.
Tom Aker here. I think what would benefit me most is maybe some of the history and then some, I guess, stories, because I'm interested in hearing. And what I don't know about is what range, or trying to put in words what I'm thinking. I would think there's different levels of emotional distress. And is that different for different audiences or individuals, or how is that measured? So that's the best way I can put it, what I'm thinking about. And then I think it'd be good if we had some information, maybe some real life stories to dig into, some examples of how things may be. I'm going to use the term emotional distress heavy and emotional distress light. Is there some sort of a range that we need to be considering?
Thank you, Tom. I'm going to go to Cindy, and then I'm going to go up to Tom Wheaton. Cindy, what do you need to be able to come back in February and have this conversation, in addition to your own time thinking about it between now and then? And who, if anybody, should we be looking to in the months ahead hear from on this topic?
Well, and I think I'm going to actually sort of lean on, the lawyers in this situation, but I'm looking for some examples of case law that represents effective practices, not necessarily just in Colorado, but around the United States, that show some consistent effective practices that lead to, positive outcomes with emotional distress. Because I know, for example, in the community of deafblind, blindness, etc., there's a lot of digital access issues, and depending on what court and what judge you get, sometimes folks are so unaware of what is involved in technical accessibility, etc., that much is lost, and so you can't really look at the case law because it's clear that there was just clearly not well understood. But I'm really looking for some good examples of case law and some solid practices and requirements that we could implement as a result of that.
Thank you, Cindy. Appreciate that. And we'll certainly work to start bringing those pieces together. Let me go up to Tom Wheaton and then to Lauren on what can we provide you and what would be most helpful to you to come back in February to a conversation where we start workshopping solutions.
Well, I have two thoughts. The first one is really like to pick the brain of leaders of any type of coalition group for disabilities that have dealt with this, either through our state, other states, or on a national basis. I don't know how to plug into those resources except for a few that I know of, but if there's some general ones out there that just is a major coalition, I think that'd be helpful. And the other one is, when I do think of our end goal of trying to rewrite, are there examples of other states that have really written things well, or is really this starting from scratch that Colorado is going to kind of pave the way for the other 49 states in this endeavor? I thought I heard there might be a state or two that really had something. I don't know if it's good quality or not, but those resources would be helpful for me when we try to pinpoint what we're talking about here. That would help me for when we try to meet next.
Great. I appreciate that, Tom. I'm going to go to Lauren next. And, you've got the DORA team on here. We do have help from DORA and some staff that can help with some research. So I think you all are naming some things that we can ask them to start pulling together for us. Let me go to Lauren and then Alana.
Thanks, Lauren speaking. I guess, just because what I said earlier, it would be interesting for me to hear why emotional damages has been struck from statute, and the rationale there, if there was an opinion from the Supreme Court. You mentioned that that precludes Colorado from seeking emotional damages. And then I probably need to do some outreach too and understand, what are the implications for emotional damages if that were reintroduced into statute.
Thank you, Lauren. I'm going to go to Alana and then Andrew and Ian. I'm just going to tee you up. Given your expertise and your full-time job, it may not be so much as what you need to be able to come have these conversations. Although I want to continue to support you if there are things. I'm also going to ask you guys when I turn to you what you think we as a group need to be learning and thinking about. But let me go to Alana and then I'll go to Andrew and then Ian.
Thanks. Yeah, this is Alana. Everybody's done like most of the things that I had on my list, other people have called out, which is awesome. So just I'm seconding all of those things. The other things I guess I would add is one, we've heard some stories from the disability community, and I would always love to hear more. I would also be interested in hearing more specifically what the concerns from the business community are. Is it just fear of expenses broadly, or are there specific things that they've heard, horror stories that they're afraid of, that maybe we can mitigate that or something like that? Would be interesting to know. And then also for any best practices, or just, I guess, the law as it exists now, or anywhere that this touches, that's too broad, but basically stats on outcomes of how has this type of thing been implemented, and where has it been successful and where has it not been successful, and what are the differences, so that we can try and avoid any legal pitfalls or implementation pitfalls where if we'd looked at the data in aggregate, maybe we would have not been surprised 2 years from now, something like that.
Thanks, Alana. Andrew, what can we provide you to help? And what would you suggest we all would be well served to have an objective look and an informed conversation?
Thank you, Barrick. This is Andrew Montoya. I agree that hearing stories from people in the disability community who have lived this and know what discrimination feels like is very important. I also agree that hearing stories from the business community and kind of pinning down what the actual concern is. I mean, obviously everyone's afraid of the unknown and no one wants to spend money they don't have to. But beyond that, what are the concerns? And from my perspective, as you said, doing this as my day job, I think also hearing some of your concerns, the others on this subcommittee's concerns and thoughts about what you might need, so that I can dig into that a little bit and be a little bit more prepared with some answers. For example, perhaps I can do some research and find some case law that would look, that would answer what Cindy's looking for. One thing I've heard some folks talk about, the process, best practices, things like that. And I guess I'm not quite clear on what that means. When I consider emotional distress damages, I'm considering that a remedy. So it's, if this happens, then you're entitled to emotional distress damages as determined by a jury. Obviously that's where my mind would go. But what do you guys mean by, best practices when you say that?
Thank you, Andrew. Ian, things that would help you to have an even more well-rounded view and insights into this, and things you think we would be well served to support conversations.
Thanks, Barry. Ian. I guess first I'd like to say that I think everything that everyone has already flagged. I know Alana seconded everybody, and then a couple people spoke after her, so I guess I'll third everybody who was already seconded. I think these are great. I mean, these are all the right questions that everybody's asking, or the right things that they want to hear. I agree with the recommendation of hearing stories. I think it helps to humanize this for people, and I agree with Andrew to hear from the businesses as well. I do think it's important. I guess what I think, I mean, and maybe I'm kind of putting the cart in front of the horse by saying some of the things that I think might be helpful overall are explanations of the process of, we've had some discussions about litigation and the way litigation works. Andrew talked about, for example, a summary judgment motion being granted the night before trial, or some outcomes, statistical outcomes, so people have an idea of the reality of what this type of litigation looks like on the ground, as opposed to through a vibe or a feeling, right? And I don't want to be the one to just come to you and say, hey, this is what the stats are, right? But I know what the stats are. I know how many civil cases get filed in federal court every year and how many actually go to trial. If there are things that we can provide, like Andrew offered in terms of research. Lauren, for example, mentioned the holding from the U.S. Supreme Court case, and that's the Cummings versus Premier Keller rehab case from a couple terms ago. I mean, I can explain that to the committee if the committee wants to hear that explanation. And if you guys want to give Andrew, I shouldn't volunteer Andrew, but I'll volunteer myself. If you want to give us some homework for some of these things that we can bring back to you, I'm happy to do that. I do think, the comments about what people are doing elsewhere. I've reached out to colleagues outside of Colorado. What's going on in your state? How are things being handled, with respect to your disability discrimination laws, to figure out, like, hey, where is an example that we might be able to look to, or what can we take from other places? If Illinois has done something well on one area, and New Mexico has done something well on a different area, can we take those things and cobble them together for us We don't have to reinvent the wheel, but we might be able to make a nicer wheel.
Thank you, Ian. Cindy, I'm going to give you the last thoughts on this, and then I'm going to pivot us a little bit with my commitment to all of you. This is obviously a continuing conversation, but Cindy, what are you thinking?
Well, yes, I actually just want to follow up on Andrew's question, which is to give more information, to give some direction for some examples. And so I'm wondering what is going to be the best avenue for us to have that conversation offline.
I'm going to ask Carrie to follow up with you, and we'll get with you directly on that. Just so everybody's aware, I have to be very careful because we may be making policy recommendations. I have to be very careful in not facilitating or encouraging, and in fact discouraging members of this group from talking about the work of this subcommittee and of the task force outside of these proceedings. But Cindy, Carrie, and I will follow up directly with you.
Okay, because I didn't know if we needed to, submit some examples or give specific situations such as employment related, et cetera. So that would be helpful.
Yeah, I think all of that. So we'll reach out to you. Rep Ortiz, please.
My understanding is that if like people want to break up into smaller groups, as long as it's announced and made open to the public, that then it's allowed. So I don't want people to think that you can't turn to working groups outside of this. You just have to make sure that, according to the core and the sunshine laws, that you announce it to the public and that it has to be open to the public. Yeah. So just keep that in mind as well.
Yeah, thank you. And we may well need to do some of that. I just wanted to make sure that we didn't step afoul by saying, hey, Andrew and Ian, why don't you guys get together and tell us what is happening? I need to protect the integrity of this group, but Rep Ortiz is absolutely right. We have the ability to create some of these one-off groups. What I want to do, we're at 4:21, and I want to make sure I can get you guys wrapped up on time. Carrie, I'm going to ask you to spend hopefully no more than 5 minutes just sharing with people a high-level overview of some of the tools that we have. This will be the first of several times. We will do a more comprehensive demo down the road, but I want Carrie to be able to give you guys a sense of what the tools are that we'll be able to use on an ongoing basis. And then I'll finish this up, just closing the loop on our next steps and each of the actions.
Sure. Thanks, Barrick. I am, for the sake of those using a screen reader, I'm not going to share a screen, but I'm going to encourage you all to go to engagedora.org, and I will send around a link shortly, but they have built out a stakeholder engagement tool that we can fully customize to our needs. Our specific page for this task force is not up. We hope it will go live first thing next week, but this subcommittee will have its own dedicated page where transparency is a huge issue. Something that we want to share with the public, everything that is collected and gathered. On Engage, we will be able to collect stories, those with lived experience, expertise in the field. Anybody we want to engage with, we'll be able to share that link. They will be able to easily provide feedback for the subcommittee, for you guys to review, keeping in mind anything and everything that will be collected is subject to those open meeting rules also. So it will be public. We'll keep it all in a public folder. So everybody will be able to access those materials also. But it's going to be a pretty powerful tool. If any of you have stakeholders or those with lived experience that would like to share a story, share some research materials, you'll be able to share that link directly. It will be easy for anyone to upload those materials. But I am also going to put myself out there. Lean on me. If you have somebody you want to introduce to this subcommittee or to the task force, shoot me over their information. We can get them involved in the best way, whether you want them to come on and give a quick presentation at one of your upcoming meetings, or you think they have valuable information that they can share going forward. And that goes for this subcommittee. And if you have any ideas for the others as well, or for the main task force. But certainly those stories that you guys are all asking for, there is going to be an easy way for people to share, an easy way for you to ask for them and reach out to the communities as a whole. So I'll be sharing more of that information probably early next week. But if you want to go online and just take a quick sneak peek at one of the projects they have at right now, they have a homeowners task force that is operational right now and will be mirroring a lot of the same information that you'll be able to find on there. So if you have any ideas for engagement, also shoot them over to me and lean on me. And as Barrick said, we do have somebody coming online that's also going to be a dedicated research person for us. So I've captured a lot of what you guys have said here, and we'll follow up with them and see what we can get in advance for our next meeting.
Thanks, Carrie. And I just want to layer on a few things to what Carrie shared. Number one, this has been designed intentionally to be an accessible platform. That said, I know that even I have problems with some technology. So if people need extra support, as Carrie said, reach out to us. We also will work with all of you. This is not intended to be the only forum for stakeholder input. It's just the one that can reach the broadest audiences. But if you tell us, for example, next month, we need to go do a webinar with this group to hear from them. We want to take your guidance there. The other thing I just wanted to touch on, Carrie mentioned that what gets collected there does become public record because this is a public body. There is nothing that requires people to provide personally identifiable information. If they wanted to provide their full name, they're welcome to. But if they want to instead provide a first name and initial or something like that, we don't want this to become something that people are intimidated from sharing their thoughts. You will see on some, like all forums where the public can provide comment on other people's posts, it can get interesting. So we are going to have a conversation with you. This platform has the option to either display everybody's stories or just collect them. My current thinking, and it's a topic we'll talk about on our next meeting, is to collect them rather than publishing all of them on a live website. I've just seen some other cases where what people submit is not the friendliest type of dialogue. And I don't intend to censor anything, but we'll have a conversation with all of you about how best to utilize that functionality. With that, let me just go over some next steps, and then if we've got any quick questions, I'll cover them. From our side, as I said at the top, we're going to get off of here and we're going to send that report out to all of you so you see exactly what it was. It was what was in our discussion documents, just put into a cleaned up document. We'll also circulate shortly the latest versions of the definitions, including the one on essential functions that Ian did. And you'll see it also has some comments. So you want to look at it in a format where you can see those, where Ian let us know what case law it was coming from. I think there's some that cited the 8th, 9th, and maybe even 10th Circuit on some different issues. So we'll circulate those definitions. We'll also work with all of you on having a one-off call on the definitions. I think we're seeing these conversations will easily consume our time together. So I want to make sure we have time to talk through those initial batch of definitions. We'll follow up with our notes. I'm going to also follow up with some questions on additional things like we just talked about the learning. To tee up our February call, the first order of business will be continuing this. Hopefully with us having been able to share some more information with you, all of you having been able to do some thinking on this. And then the back end of that call, we will start this conversation for the next topic, for CAPS. So be ready to start offering not your in-depth thoughts on that one, but where you're going to enter the conversation. And I would ask you to really reflect on what you heard from your colleagues on today's call, so that our next call, we start really thinking about putting ideas on the table of what a framework of a better system could look like, and getting even more into the weeds on who we need to hear from. Before I wrap us up, does anybody have any final questions or comments for the group? Mr. Montoya, please.
Thank you, Barrick. This is Andrew Montoya. I've got one other item I'd like to add to the list of potential things that we can, if possible, if it's not too late to do so. And that involves attorney's fees. I was working with another statute recently. It was the one passed shortly after the George Floyd incident to hold law enforcement more accountable. One of the things they did there, and I would love to see that re-put in, well, not re-put, but put into the Anti-Discrimination Act here, is the sorry, the word just escaped my mind. Catalyst theory for attorney's fees. Essentially, what that means is if a defendant at the very end of a case decides to pull that, hey, I'm going to change my policies, therefore mooting your case. If we can show that the lawsuit was a substantial factor in them changing their policies, then attorney's fees would still be allowable. Again, that was the way that the ADA operated for decades until there was a Supreme Court decision, Buchanan, that overturned that and said that catalyst theory for attorney's fees is no longer workable. But unfortunately, that's resulted in a lot of cases where that very much does happen. We get near the end of the case, and then the defendant decides, hey, chances are we're going to lose this. So they institute whatever policy that we've been asking them for and say that the case is moot. And so not only do our folks then not get an order to fix the problem, don't get any sort of damages, but then we also don't get any attorney's fees, which allows us to continue doing this sort of work.
Thank you, Andrew. I certainly don't see a concern to including that. We want to make sure we're comprehensive in this. We'll continue to work with where that fits in the sequencing. I would guess that'll probably come mid-spring, and that may lead to some definition discussions as well. With that said, it's 4:30. I want to honor your time. I want to thank all of you. For those who weren't watching the chat, you had a couple of thanks for the candor and the professionalism of the work here from Representative Ortiz. So I want to name that. And with that, we will follow up. It is Thursday, so realistically expect to hear from us early next week with some minutes and some next action steps, as well as details on our next call. Thank you all very much, and we'll be in touch by email, and we will see you in February.
Thanks, everyone.